Ladies and gentlemen, welcome to the National Constitution Center. I am Jeffrey Rosen, and I am so thrilled to welcome you to this Temple of Learning, which has a very inspiring mission. And those of you who have been here before know the mission, and those of you who are here for the first time are going to hear our wonderful members recite it with me. And I want to recite all of it, because I think it's important to get the second clause now. Part of your homework assignment is to memorize the entire mission statement. So here we go, and we're going to do it together, and we're going to do it slowly and with feeling. The National Constitution Center is the only institution in America chartered by Congress to disseminate information about the U.S. Constitution on a nonpartisan basis in order to increase awareness and understanding of the Constitution among the American people. That second part is so important. Thank you for saying with little government support. It is important to note that despite this inspiring charter from Congress, we are a private nonprofit, and that's why we rely on people like you, members, passionate lifelong learners, to convene, to come together, to join the center, to become engaged and involved so we can spread the light to the world. But that idea of increasing awareness and understanding of the Constitution among the American people is such a meaningful and important charter. We have a series of exciting programs coming up that are part of that mission, and I hope you'll join us. On March 15th, we have Joseph Ellis and John Meacham talking about renewing the Founders' Promise. On March 20th, the debut of that thrilling new biography of William Howard Taft, which I am so happy to be publishing then, and Judge Doug Ginsburg will be interviewing me, and it's going to be a thrill. And then please join us in Boston on March 29th when Justice Stephen Breyer is going to talk about the future of the First Amendment, along with a brilliant series of scholars who will debate its original understanding. So that's why you've got to become members of the Constitution Center if you're not yet, so you can get on the lists, follow our programs, listen to the podcast, and spread all of this educational light with the world. Ladies and gentlemen, as you know, I'm very passionate about constitutional education. And my passion for this great mission began in law school, where I was privileged to study with some of the greatest teachers of the Constitution in America, many of whom you've met, including Akhil Amar, who was here just last week to launch the new C-SPAN series on landmark cases. And it's such a personal honor and privilege to me to welcome tonight, first of all, for the first time, some alums of Yale Law School who are here, and also the new dean of Yale Law School. Heather Gerken is one of the country's most important scholars of the Constitution and election law. She's written about issues ranging from gerrymandering to voting rights, and she has become the intellectual guru of a movement that has been described as a nationalist version of federalism, progressive federalism, the new federalism. We're going to talk about what exactly the right label is, but she is creatively reminding us that the values of the balance between state and federal power can be used by people on the left as well as the right to create national consensuses that can transform the meaning of the Constitution. I'm so looking forward to this conversation. Please welcome the new dean of Yale Law School, Heather Gerken. Great. Please. Heather, I'm so excited that you're here, and I want to begin with the interactive Constitution. All of our great members know that the Constitution Center has, I've got my earphones, which I have to come out at the same time as I bring the interactive Constitution, but if you haven't downloaded it yet, go to the App Store and download the interactive Constitution, and when you call up the section on congressional power, you will find Heather and Randy Barnett talking about the meaning of federalism. And I need my constitutional reading glasses to find it right away. But so here we go. It's Article 1, Section 8, here we go, I found it, because of the brilliant technology which makes it easily accessible. And Heather and Randy Barnett, the two leading scholars of federalism in the country, nominated by the Progressive American Constitution Society and the Conservative and Libertarian Federalist Society, wrote a 1,000-word statement about what they agree Article 1, Section 8 means. And you can be confident, like a Supreme Court majority opinion, every word in this common statement is agreed to by both sides. And Heather and Randy said that from the post-founding period through the Civil War, through the New Deal, and to the Rehnquist Court, there were 4 eras of federalism in our constitutional history. And I'll just remind us what they are. Enumerated powers federalism at the time of the founding, fundamental rights federalism during the Civil War, New Deal federalism, and then today, state sovereignty federalism. Why don't you begin, Heather, by telling us briefly what each of those eras were?
Sure. So by the way, it's lovely to be here, and I particularly just want to thank Jeff for inviting me and for calling me an intellectual guru in the New York Times, which I've gotten a lot of play out of. Although the morning it happened, I was reading the New York Times. It was 6 in the morning, and I was trying to figure out how to put the crumb collector into my new toaster and unable to do so. So take it with a grain of salt.
That's very true.
So the history of the Commerce Clause is in many ways the history of federal power in this country. Everyone agrees, no matter who you are, no matter which side you're on, that the framers intended for Congress's power to be limited and enumerated. And one of the powers that they gave to Congress was to regulate interstate commerce. That was a very simple thing, and back then it seemed limited. But as time went on, federalism transformed into something quite different because the commerce power turned out to be limitless. And so in some ways the story that Jeff just articulated was a story of the court struggling at different moments in its history to place limits on what the power that the federal government could wield. So it began with this enumerated powers operation. During the Civil War, it took, as you know, a quite different turn, federalism did. And then we reached a period prior to the New Deal when you see justices desperately trying to put limits on what commerce was through formal definitions. So you end up reading these crazy cases, they're my favorite cases to teach, where the question is a slaughterhouse part of the throat of commerce? Are objects in rest or in motion as they move through the river of commerce? All these kinds of efforts to analogize what's happening, when what's really happening is that commerce is taking over everything. And ultimately, when we reach the New Deal, the court throws in the towel. It just decides it can't figure out a way to limit federal power, and so they basically license Congress to regulate anytime there is interstate commerce, and there is almost always interstate commerce at some point or another. And as we move later on, the only defense that the court can come up with is no longer to limit interstate commerce, right? That seems limitless. But to sort of build a wall around state power to shield the states from regulation. That's the sovereignty move. And so that's the story, and it's a story of a court doing what both Randy and I agree they were intended to do, which is limit federal power. And the difference between Randy and me is that I think that they are on a quest that is impossible. That, you know, there was a king, famous King Canute, who was famous for trying to hold back the tide. Not even a king can hold back the tide, and certainly the Supreme Court has not been able to hold back the tide of congressional power.
And that is why in your separate statement on the interactive Constitution, you say that rather than thinking of federalism in terms of autonomy, you prefer a notion of relational federalism. Tell us about that.
Sure. So the old model of federalism, what I think of as your father's federalism, and I always use that line with Randy because he's just a little bit older than I am. Your father's federalism had this model of state power. So how did they think of states? They imagined states as presiding over their own empires. So the idea was there'd be this area where states could regulate free and clear of any interference from the federal government, and the federal government couldn't invade that terrain. So it used to be, for example, that people thought that schools and police and crime and other parts of state power were sovereign, autonomous, areas where the federal government could not tread. That's the model, and you know what happened. The federal government's power washed across those shores. And if you're Randy Barnett, you mourn that decision, right? You think that's a sign that the states are losing power because they no longer have autonomous areas where they can regulate entirely by themselves. What I say to folks like Randy is that states still have an enormous amount of power. It just takes a different form. These days, the form of state power is relational. It is because the federal government depends on the states to get anything done. So if the old kind of vision of state power was an empire presiding over his own empire, I think the right way to think about it is two people shoulder to shoulder. Sometimes they lean on one another and sometimes they deliberately jostle one another, but they're always connected. And I'll just give you examples. If you think about where have states been exercising power lately, what you see is that it's almost always wielding the power that they own because the federal government depends on them. So I'll give you two examples, one red, one blue. Marijuana law. So remember when Colorado and Washington legalized marijuana? They did not change federal law. Federal law remains the same and it outlaws marijuana use. So how is it that they legalized marijuana? The federal government does not have anywhere close to enough boots on the ground to enforce marijuana law. So when the states withdraw their enforcement apparatus, they effectively make marijuana legal, right? Because the federal government can't rely on them anymore. So that's a blue example. Or the red example, think about Obamacare. So there's the federal government, right? It wants to create a national healthcare system. It does not have the resources to do it by itself. It has to rely on the states who have long been in this arena. And so what Obama had to do was bargain with red states across the country to pull them in. So he cut deal after deal after deal. Why? Because he couldn't do it by himself. He needed the states. So that's relational federalism, where the power that you wield is because the two sides depend on one another, not because they're separate and apart. They're not kids playing, in parallel play, right? They're really interacting with each other constantly.
Because of relational federalism, you say that at a time when ours control all three branches of the federal government, progressives can use the states to resist. And you say that forms of resistance include cooperative federalism and uncooperative federalism, and sanctuary cities is just one example. So give us a sense of what cooperative and uncooperative resistance techniques involve.
Sure. So this is actually, I just want to say I've been writing about all of this since 2002. So I've written about it under Republican presidents and Democratic presidents. I've written about it for both blue and red. And I will tell you that my progressive friends have not been all that interested in federalism until November of last year. And then I got calls, wow, your work is so brilliant. If I had only known. And so I don't mind that progressives are late to the party, but what are progressives doing now to resist the federal government? They're using that power I described to you, that power of dependence. And the sanctuary cities is probably the most spectacular example because as with marijuana enforcement, the federal government doesn't have enough resources to enforce its immigration laws. It needs the states and cities to help them do it. And when states and cities say, we're not gonna do it for you, it puts President Trump in a bind because he needs them to move forward with his agenda. He needs them to do it. So right now, the sanctuary cities and the sanctuary states are resisting federal power. We used to call these regimes cooperative federalism, right? Because the idea is the states are cooperating with the federal government to carry out a program. But as my co-author and I pointed out a few years ago, there's cooperative federalism and then there's also uncooperative federalism. Once you have the ability to carry something out, you also have the ability not to carry it out, to throw a wrench in the works, to resist. And that's exactly what you see progressives doing on all sorts of fronts, but particularly the sanctuary city movement.
Now, the executive branch has tools at its disposal to fight back. Both President Obama and President Trump have threatened to withhold funds from sanctuary cities, and yet the Supreme Court has imposed limits on the federal government's ability to coerce the states. What are the constitutional restraints on the president's power to push back?
Exactly. So once the president's kind of in a bind, right, when he can't get the states to sign on. And so what are the tools that he might use? One of them is money, 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 right? The states and cities are desperate for federal funding. And so often presidents use money as a carrot, in effect, to encourage people to do it, or somewhat as a stick by cutting off federal funding. So what President Trump did very early on in his tenure was to issue an order that would deny cities and states all federal funding, huge amounts of money, if they didn't comply. The problem for President Trump is that ran afoul of these Supreme Court decisions, because what the Supreme Court has said is, you can bargain, you can bribe a little, you can play the game with money, but you can't hold a gun to their head. That is, if you are withholding so much money that it's not really a deal, it's not a negotiation, it's a gun to the head, then that's unconstitutional. And so that's exactly the problem that Donald Trump ran into. He used too big a stick. And as a result, he's been tied up in federal court ever since.
And yet you think many of these Supreme Court decisions, by focusing on either state autonomy or the limits of congressional power, don't accurately capture relational federalism in its complexity. Are there examples of Supreme Court dissents that you think get it right?
Oh, that's a great question. So the reason I don't think the Supreme Court has the same model of state power in its head that Randy Barnett does. I don't mean to pick on Randy. I love Randy. So but they have this model that they have to shield the states from power, and so they've done all these things to try to protect states from any federal regulation. It's just not worked because the federal government has too many tools in its toolbox. If they were really serious about it, going back to the conversation on interstate commerce, they'd have to shut down interstate commerce, and they're not going to do that. So I think that most of those decisions are wrong-headed because they just have the wrong image of what power is. I do think the spending clause ruling is a good example of relational federalism. So this case came out of the healthcare case, where you see a lot of the traditional old school fathers federalism rhetoric about states. But then when the court gets to the spending clause question about what kind of carrot can Obama use, they start to think about the relationship between the state and federal government. And they think about how long has a relationship existed? Would the states have known that the federal government intended to make this dramatic change? Was it too dramatic a change so it wasn't part of the same program? Was it too much money? That's the kind of way the court should think. It should think about, how do we create fair bargaining conditions between the state and federal government? Not how should we shield the states or limit the federal government, but how do we make sure that bargaining conditions are fair? That's a decision, I think, whatever you think about the merits of it, is the right way, at least, to think about state-federal relations.
You're an intellectual guru, and I want to figure out what to call the movement that you're the head of. And some have called it nationalist federalism, but that phrase now has an unusual resonance. So what would you call it? and what exactly is a nationalist vision of federalism?
Yeah, so I just want to be clear about nationalist federalism. It is not the sort of nationalism we've been seeing post-2016. It's New Deal nationalism. So a lot of people who, I am a nationalist in that sense. That is, I believe in a strong federal government. I believe that the federal government should be able to regulate when it needs to do so. I believe in a national democracy. I believe in national norms. I believe in national conversations, all of those things. And yet I still think states have a role to play, a really important role in helping our democracy function. So normally the two camps are the nationalists, it sounds like a baseball team, I know, the nationalists, right, and the federalism folks. And they kind of are at war with one another. I'm somewhere between those two tents because I agree with the nationalists. I have the same values, national democracy, national values, national law. But I also think the states have a huge role to play in creating a healthy nationalist democracy. So that's what I talk about when I have my academic hat on. When I'm out in a world with people who aren't quite as sophisticated as all of you, I often call it progressive federalism. I say that because the people who doubt federalism are always the progressives. So you don't need to say conservative federalism, you just say federalism, and the conservatives are all in. But for progressives, they've long been reluctant about federalism, and with every good reason. So progressives worry, correctly, about the fate of racial minorities under our fathers' federalism, right? They worry about the ability of the federal government to carry out its duties. And I share those worries, and if this were our fathers' federalism, with the old states' right model, I would reject federalism. But that's not what happens anymore. Right now, the federal government, if it wants to regulate, it can. But it's also very helpful to have states out there. And I think states are helpful even on the front of racial equality and other forms of equality.
tell us more about how they can play that role. You say it's not just the First and 14th Amendment that can advance equality, it's activism starting at the state level. And yet you reject the famous aphorism of my hero, Justice Brandeis, of the states as laboratories of democracy, which you think is a little simplistic. So give us an example of equality building up at the state level, and how does it work?
Sure. So I think one of the things that again, a sophisticated audience like you knows, but most people don't, is that rights are like families. They're built, not born. Right? So we sort of, some people, I think, in an unsophisticated way, think, oh, rights are just the thing in the Constitution. They come from the sky and they exist, and then therefore we have them. That's never true. They're just paper. If you want rights to be real, you have to build norms around them, right? You have to give them life. And the best example is the Reconstruction Amendments. So they were, for many, many generations, just a paper guarantee, meaningless to the communities they were supposed to help. So how do we breathe life into them? We created social movements, right? The civil rights movement. We breathed life into them so that they became real. I think that federalism has a role to play in that. And I'll just give you my favorite example, which is the same-sex marriage movement. So if you just put yourself back 2002, 2003, early days, what was the same-sex marriage movement doing? It could not win at the national level. At the national level, they were outnumbered dramatically. So what did they do for LGBTQ equality generally, and the same-sex movement in particular? They went to cities. They went to progressive cities, and they started passing laws that were helpful to protect gays and lesbians. And then over time, they built it up to go to states. And so, you remember this moment when Massachusetts and Gavin Newsom in San Francisco were marrying same-sex couples. Now, why did that matter? It mattered because state and local power gave them a tool that they didn't have otherwise. So proponents of same-sex marriage had done all the things that you do when you're a dissenter and trying to change people's mind. They'd marched, they'd written editorials, they'd jawboned with their neighbors, they'd done everything they could, and they had not got traction. So when did the debate pivot? It pivoted when they were able to actually marry same-sex couples using state and local power. And I don't know if you all remember, some of you look a little young in this audience to remember, but for those of you who do, you remember that moment in San Francisco when the same-sex marriage movement, I think, was really, brought to life, because into our pictures were beamed couples, except for two were wearing a wedding dress or two were wearing tuxedos. They were, it was this wonderful moment where people could see a real life instantiation of the idea. And the moment that happened, they eliminated a large number of arguments that were made in the abstract before, right? There was a parade of horribles that was already invoked, and then it turns out, I remember Governor Schwarzenegger said that if they marry same-sex couples, there will be riots in the street, right? Do you remember that? And the only riotous moment was the gay men's choir serenading everyone as they went by, right? So that's important too, though, because it told us something about how strongly people felt. So if people were asked in a poll, same-sex marriage, yes or no, they would say no. But it didn't matter enough to them to get on a bus. So I was in Cambridge when the marriage licenses started being given out, and I thought there might be some protest. It was quiet, because people did not care enough to get on a bus. And so suddenly you saw room for compromise, and you were able to give people a real-life instantiation of the idea. And so people then started getting the same idea. You saw clerks across the country suddenly marrying same-sex couples, just sua sponte, as lawyers would say. And then the movement built over time. So they started building little by little until they had enough momentum to start a national conversation about this. That is what states and localities allow dissenters to do. And you can't do it with the First Amendment alone. So I always think of the First Amendment and federalism as interlocking gears, right? They're both tools to change things. They don't always move forward, sometimes they move backwards, but they are both tools to change how people think.
So this is a powerful example of how local minorities, by building up a consensus state by state, can create national majorities. Give us an example of how the right has done that. The Second Amendment might be one example, according to David Cole's really interesting account of how in the 90s agitation at the state level changed state constitutions and persuaded the Supreme Court to change its mind. or give us another.
Yeah, so guns are an excellent example, and they really were, it's sort of a remarkably how powerful it was. Another example is abortion restrictions. And note, and this is why Jeff noted that I'm a little skeptical of the idea of laboratories of democracy, because the image of laboratories of democracy is they're just 50 states just letting every flower bloom and everyone is experimenting. They're two labs. One is red and one is blue. And they're running the experiment through the states and localities. So, and one of the things you see, for example, if we were really in a world with 50 labs, people would wait for the experiment to finish before they adopted the policy, right? You'd say, did that work over there? If it didn't, we won't take it. Instead, what you see is really quickly, interest groups are moving through state by state, city by city very quickly to pass these laws. And so you're really seeing sort of whole legal systems emerge at the local level that can be easily plucked and put in the federal level when you get into power.
How does that change the dynamic? There are templates that are drafted in DC, introduced in some states, and then go all red or all blue. The no monument removal law may be an example, and there are lots of others. Is it a genuine democratic debate as a result, or not?
You know, that's a really good question. Some of these things, it depends on who's running the interest group. Some of these things are quite organic, and they're coming from grassroots organizations, and they really are like-minded people looking across to other states and cities and seeing something they want to do and bringing it in. Because it's much easier to cut and paste than to draft the regulation from scratch. Some of them are run by really powerful interest groups with hidden money. So you shouldn't assume just because something's getting passed that there's always robust democratic support for it, right? It's just like anything else in our democracy. Sometimes it is, and sometimes it isn't. At the very least, though, it's giving us a lot of sense of how things work. Healthcare is a perfect example. So Massachusetts, that Romney Care, right? That became a national example. So it gives you a chance to see whether something works and tee it up for the future and tweak it. But I think a lot of it is being run by groups that are nationally networked rather than organically local.
So this question of interest groups leads to a question I've been really eager to ask you because I'm very eager to know the answer. James Madison feared factions, and he thought that the greatest evil in a democracy was that interest groups would agitate not for the public good or for private rights, but for their own self-interest. And he thought the antidote to faction was an extended republic, because over a large geographic territory, it would be hard for interest groups to organize well enough to be able to coordinate and stand up for their own selfish interests. As many have noted, the internet has challenged the Madisonian model. It's really easy for factions and interest groups to organize in dispersed geographic areas and to create mobs and Twitter groups, and as a result, we're seeing tremendous polarization. So how does your vision of progressive federalism fit into Madison's model? Is it now the case that we're less likely to see factions on the state level than at the national level? And in that sense, did Madison have things completely backward?
It's interesting. I mean, polarization is so powerful, and it's so powerful not just in this country, but democracies throughout the world, that it's hard to know whether it's our system or not, or what exactly is operating. But what I will say is this: when I think about Madison, I think his mistake was to think that it was moving it up to the national that would eliminate the problem. I think what we in fact have done is we fractured them. And I'll just give you an example. If you are a powerful interest group, you just need to capture one agency in Washington, right? One part of the Senate, and you can get your agenda through no matter what. But when you have 50 states, it's really hard to capture 50 states. And so even, and you see this all the time, right? Even when the national government is putting a halt to regulations or doing something that an interest group is moving it forward, at the state and local level, there's a lot going on, and it's very hard for that interest group to capture everybody, partially because we're so different politically. So I'm not sure if this reduces polarization enough. I mean, there are benefits, I think, to forcing people to talk to one another, and that is, I think, the signal virtue of what I call our federalism in the spirit of the Supreme Court. That is, Donald Trump, for example, at this moment, controls everything in Washington. He does not need to negotiate with a single Democrat to get things done. But he does have to negotiate with Massachusetts, California, with San Francisco. He depends on them, and so red has to talk across to blue because of the way. So does it reduce polarization? That any political scientist would weep if I made that claim. But I will say that at least it's an effort to bridge the gap once polarization exists.
Let's dig into this. Madison thought that at the state level you'd pass laws really fast and they would threaten property rights, whereas at the national level it would slow things down and be harder to get stuff done. But has the opposite happened now, where you need you can pass laws quickly when you control all branches of the federal government, but because of relational federalism you need to bring a lot of different states on board in order to create a national consensus?
Yes, it's a good question. I think that Madison was a little bit closer. I mean, at least now, we've swung back and forth, but right now, Washington is pretty locked up. It's amazing to see, even with one party in complete control, it's still hard to get any legislation out of it. Post offices get named, but that's about it. And so, in that sense, the states put some pressure on the federal government because there's a great environmental story. If you were worried about lockup, let's say you think the Detroit car makers have control of Washington, right? Well, what do you have? You have California start passing something, and suddenly the game is no longer just a veto game, right? If you're the car interest, right, you can control Washington. You just veto every environmental regulation. Suddenly California passes something, and it really matters, and people come to the table and bargain. That's the kind of model. So states can sometimes tee things up, I think, to get us to the national level. But it's also true that all the regulation that's going on both sides, all the fights are happening right now at the state and local level. That's where people are actually passing laws, and they are passing them more quickly than the national government could ever hope to do.
Just one more beat on this. If Madison's really concerned about slow deliberation over time, and he sees not a direct democracy but a representative republic, and he says that a lot of different pieces have to come into place before you can speak for we the people. So is the virtue of relational federalism just that in order to change the views on gay marriage or gun rights, you gotta just persuade a whole lot of different states and then persuade the Supreme Court, and everything has to come into alignment? What's the relationship of time to federalism?
Yeah, it's a great question. I mean, part of the problem is, of course, Madison envisioned a place where you could have a national conversation because it was small. And it was controlled by a small set of elites who were in conversation with one another. Now it's very hard to get a national conversation going without doing something at the state and local level. The way I think about it temporally is that what the current system does is it means that the discussion doesn't end when legislation is passed. So what happens is, first you have to build up enough of a movement to get legislation. But then, because the federal government so depends on states to do much of the work that it's doing, the conversation extends afterwards. So we're still having a conversation, right, about the implementation of Obamacare. And interestingly, the conversation is happening with different people. So we had our conversation with the legislature, but now it's state bureaucrats talking to federal bureaucrats, it's governors talking to agencies. There's a way in which the conversation has been stretched out precisely because you depend on those states and localities to do what they're supposed to do, which is why the same-sex marriage movement is such a good test. Because in the wake of the same-sex marriage movement, the United States Supreme Court declares that same-sex marriage is the law of the land. They still need all the clerks in the country to continue with those marriages. They still need states and localities to continue with those marriages. And right in the wake of the decision, I was amazed how little protest there was. It almost looked like the conversation had ended and that we had reached a national consensus, but note what's happening now. Conservative states are starting to pass the Baker laws. And so the conversation is being extended. I mourn that because I'm a supporter of same-sex marriage as a person. But nonetheless, you can see how that conversation is still being extended because the consensus has not been reached yet.
This is a really optimistic insight. So cooperative and uncooperative federalism are not just resistant tools, they're ways of extending the Madisonian conversation to ensure that no one branch gets to speak for we the people unless all the pieces align.
Exactly. So Bruce Ackerman always says that the magic of the federal government is It instantiates the people in three different ways: the president, through the Senate, the House, and the presidency. Right? It represents the people in three different fashions. But in some ways, if you actually add the layer of the states, they're also representing the people, but in a quite different fashion than that. So I think it is an added part of the conversation.
So for those of us who are concerned about how to slow down deliberation in an age of Twitter and social media, federalism is one answer.
It is true. I mean, I'll just say Twitter has given up on the healthcare debate, once legislation passed or the Supreme Court decision was made, but it's an incredibly active question right now. It's just Twitter's not paying attention because it's bureaucrats involved in the conversation and localities involved in the conversation.
It's a very complex vision of federalism, and the Madisonian model was complex as well. You used the adjective hydraulic at one point. Talk about the complexity of the various pieces interacting.
Sure. So actually, one of my colleagues said to me, "I hate your work." And okay, luckily I'm tenured. He said, "I hate it because I want things to be simple, and what you're describing is really complex." And now he says, the trouble is, he says, I think it's true. So complexity is what we see. None of this is simple. And so the sort of hydraulic power, the hydraulics of power are that when you shut down something at one place, it often pops up later. So the same-sex marriage movement, right? We thought we shut down the conversation about it. It's popping now up in all these state laws regulating what you have to do for weddings and things like that. We at some point thought we'd reached a consensus on civil rights, but what happened when states and localities had to carry it forward? We discovered we hadn't, and the conversation continues, and power just goes and finds the place where it matters. So I suppose it's in some ways there's a healthy letting off steam in some ways, right? No one is ever completely shut out of power. I mean, just think how polarized we are now, and how desperate we are at this moment. Worrying that one side or the other will control everything. Each side almost looks upon the other as a monster. And so it would be terrifying if they controlled power. If you really think the other side is a monster, you don't want them controlling everything. But that never happens with us. There's always a blue state or a red state at a point when there's a blue Congress or a red Congress.
Should originalists celebrate your model? Is it a Madisonian model or is it something else?
It's, so this is where I resist the originalists. Because the originalists have an idea that their model of sovereignty was what the founders believed. I just think they're wrong about that. And there's a great book about Madison that showed that Madison himself dramatically revised his view of what happened at the convention over time, over 50 years, dramatically revised it. And so. And it was true, and if you look in those papers, what you discovered about those debates is that at some point they didn't really know what states were going to be. Sometimes they thought they were like corporations. What were they going to be? So, we just don't know enough of what the founders thought. And even if we did know, we wouldn't know how to apply it to something that looks so different these days. So I always resist the originalism a little bit, and I don't worry too much about it because I'm not the only one. The Supreme Court. Almost all federalism doctrine speaks in exactly the cadence that I'm talking to you about. That is, almost all federalism doctrine at bottom is about civics. Whenever the Supreme Court talks about federalism, it tells you why we have states. They are laboratories of democracy. They're forces of resistance. It's the kind of thing that you can talk about. It's all about preserving a well-functioning democracy. So I have a different view about how to do that. But the way the court makes doctrine in federalism is really about preserving a democracy in a world where you don't actually have a lot of guidance from the founders.
Sorry to ask, but what is the Madison book for our audience?
Oh, it's I think it's called Madison's Hand.
Yes,
I think
by Mary Stuart Bilder, who was here and did a great job.
Exactly.
It's an amazing book.
It's a wonderful book.
And among the many things that Madison's Hand did is revise the notes so it looks like he wrote the whole thing. He completely went back and exaggerated his own role in the
It's kind of
convention.
delicious.
It's pretty great.
If you've been arguing with originalists for a long time and you discover that the person they've been relying on changed his views over 50 years in a self-interested fashion, it's a really nice fact to bring up.
So the case against progressive federalism is that it's opportunistic, that progressives discovered federalism after 2016, and they also discovered it in 2007 when the Republicans had all three branches, but then when they controlled the branches under Obama, they forgot about it, and the same case against it for the right. Are there, aside from you, Are there any consistent Federalists, and why should both the right and the left embrace federalism consistently rather than opportunistically?
Yeah, I actually, so it's true that in politics people are completely opportunistic, and that's just to be expected. So each side invokes this when the power runs their way. But I will say for scholars, I think there are real commitments on this front. And it's funny, because I'm a little bit of an outlier since I'm a progressive on this front. I find actually I like to hang out with the conservatives because, we all love the same thing. We love it for different reasons, and they're wrong on almost every other thing. But they have been consistent on this front, conservative scholars, and I have been with them, even as we have bickered about the merits. What I think it's time to do is to give up on these camps. And so these camps have gone on for so long. There's this great description by Robert McCloskey that talks about watching aging boxers fight one another. And they know each other's moves so well that the only thing they're doing is just fighting to tire the other one out. That's where we are in federalism debates. And the debate's a little bit tired. And what I want to say to both the nationalists who are typically aligned with my politics and the Federalists who are typically aligned with conservative politics, is to say, look, we can have a detente here. That is, the federalism we have today is not the federalism that the progressives fear, and it's not the federalism that the conservatives want. It's a compromise. And so states are powerful. They're just not powerful in the way that traditional federalism folks think. On the other hand, as I say to liberals, the national government can do something if it wants to do, but states play a role in maintaining a healthy national democracy. And so the compromise has the virtue of one thing, which is it's actually a description of what's happening on the ground. And the magic of law, I'll just say, law is the only place where someone can ask you a question about a normative issue and you can answer with a factual answer. So who cares what you imagine federalism ought to be? We know what it is, and what it is a reasonably satisfying system that's working pretty well along the dimensions that matter. And I think that ought to be a source of compromise for both sides, but we'll see.
You said both sides should recognize that states are necessary for a healthy and functioning democracy. If you're making the case for federalism to both sides, what would it be?
I would say two things. So one, states matter enormously because they are sources of democratic churn. For the reasons we talked about, the same-sex marriage movement could not start a national conversation, but it could start a series of local ones. So if you want to have national conversations eventually, you need to have them in smaller settings over time with different groups of people. We're too big a country not to do it that way. So I see in a democracy for dissenters, I think for racial, I'll say on the front of race, all the big fights about racial equality are happening at the state and local level. All the movement and change is happening there. And if you want to move to real robust national norms, you've got to change things on the ground. So that's one piece of it. And the other piece of it is it's useful to have someone break federal power. So it's useful that Donald Trump actually has to talk to California and Massachusetts to get what he wants done. It's a source of moderation. If Donald Trump just had an agency that he could order around, right, he'd have much more power to change things quickly and not to listen to the other side. And similarly, with a blue president and red states, it's useful to have someone in the game, inside the room, inside the program, who doesn't agree with everything, because it just forces people to talk across political aisles.
Democratic churn and forcing to talk to the other side is a very persuasive case. All right, it's time for questions. I need my constitutional reading glasses. And here they are. How does the concealed carry reciprocity proposal fit in, and should there be a federal law regulating firearms?
So I can't answer this question, and I'm not being weaselly, I promise. So I happen to run a clinic with the city of San Francisco, and I think this is an issue that's going to matter to a variety of cities and states, and so I think I'll just, if you don't mind passing on this one, but I'll just tell you, if you're a federalism geek, that is the most interesting question on the books right now. It's a great question, everyone is trying to figure it out.
You're pleading the 10th.
Yeah.
Okay,
Not
here
the
we
10th
go.
Amendment,
Yes,
right?
no,
Exactly.
that's what I meant. This is a geeky crowd, so I knew you guys would get it.
Right.
Stop, you're killing me. Okay, here we go. How does Dean Gerken's vision of federalism fit in with incorporation of the Bill of Rights? Should courts defer to states' interpretations as they do for administrative agencies? Wow, this is such a great crowd.
You guys are
No, they
awesome.
are. But you know, you guys do this every single day of the week. It's such a privilege to speak with you and have your questions. And here you go.
That's a great question. If I actually had one of my colleagues here, he would say yes to the answer to that question. I don't think so. So this is now, if you want a kind of good litmus test for, are you really someone who's a nationalist of the New Deal sort or a federalism, this is the make or break question. I think the national government is entitled to interpret its own constitution and to have that be the national law of the land. So I don't think they have to defer to states.
What does history teach about that question? We've had debates about this dating back to Jackson and so forth.
Yeah, the history is really I mean, when I teach my students about incorporation, there's a giant, I love that I can talk about this with a large group of people and not just my students. There's a big debate about how to incorporate and how to think about it, because the Bill of Rights was not written with this in mind at all. They were worried about federal power being too great. And the trouble was the Civil War changed everything. So up until then, the worry was an overweening federal government. When you got to the Civil War, the worry was states. And when up until then, you were worried about state power. But after the Civil War, you were worried about individuals. And so that led to the incorporation debates, to how to think about the Bill of Rights as they worked against the federal government. And some people said just incorporate everything. And some people said to do so selectively, and some people said that the history mattered, and some people said it didn't matter at all. My own view on this one is I actually think you probably should actually incorporate one by one, because I think that otherwise you might do injury to the right in question, but it's really tricky, and it's not what the court did.
So this is very geeky, but obviously really interesting. Your colleague Akhil Amar says that the federalism provisions of the Bill of Rights should not incorporate. So for example, the Establishment Clause, which was, I love this because I get to use my SAT word whenever I talk about Akhil's theory, it was originally an anti-disestablishment provision. It was designed to prevent the federal government from disestablishing state establishments like Congregationalism in Connecticut. And he says because it was designed to regulate state and federal power, it doesn't make sense to see it as an individual right that applies against the states. So what do you make of all that? Yeah,
I mean, I think he's totally right on the history. I think, so this is why courts have to decide if they're really originalist or not, or are they what Justice Scalia would call a faint-hearted originalist? Because I think on the history, it's a very strong case. And so you have to decide, as with all the amendments, what are you going to do about the history? We have the same problem with the 14th Amendment, right? We know at the time the 14th Amendment passed that there were federal schools that were segregated. And so what does that mean about Brown v. Board? If you are an originalist, Brown's a hard case, as I'm sure all of you know. But if you think that the Constitution embodies a set of principles that have to be interpreted over time as things change, then and understood at a higher level of generality, then it's not a worry.
I'm just curious, you're not an originalist. Is there a theory of interpretation that you adhere to, and does your federalism influence it?
I hate to tell you what a common law lawyer I am, although I worked for the person I think of as one of the greatest common law judge around, which is David Souter. So David Strauss at the University of Chicago says, forget all these theories, the way to understand constitutional law is that it's common law constitutionalism. So what does he mean by that? Common law is what courts do over time as they take a set of principles and apply them to different situations, and new principles emerge and principles are refined, and over time a coherent body of case law emerges. It's in contrast, most people think, to the Constitution, right? Because the Constitution has a text and it has original understandings. And so people say, well, no, that can't apply. But David Strauss says, look at the doctrine. Virtually all of our doctrine evolves exactly the same way that common law evolves. It's the same thing. Judges over time, taking a very sparse set of words, and applying them over time to develop a robust case law. And I think that's exactly right. And I actually think that's what courts are good at doing. And I also think it's the only thing you can do, because the Constitution does not, the text is not clear enough. It's too narrow and too small. And original history, I mean, this is the thing about historians. If you ever have a historian in the room and you want to give them highs, you say to them, so what did it really mean, right? The historians see ambiguity in everything. And they look back at things were always contested and challenged, and people didn't know how to think about it. And even if they did, it's not clear how they would think about the application to what's going on at the present. So, it's just a parlor game. Make them blush, ask them, well, what does that mean for today? And they'll start, oh, I could possibly tell you that, right? I can only tell you about what happened at this moment. Anyone who's an originalist and thinks there's clarity in history is almost inevitably wrong.
Currently, a person licensed to carry concealed weapons in Pennsylvania is not licensed to carry in New Jersey. A bill, I believe, has been passed in the House. They were trying again. It's licensed in one state.
You guys are tempting me down the primrose path.
So shall I just stop because you can't answer it?
Yeah, I think I should probably pass on.
Where can the questioner get the answer?
It's actually, so I know a bunch of academics who are desperately writing articles. So coming soon to a law review near you, you're going to see, I think, a lot of this. I don't know who's blogging about it right now. I don't read blogs as often as I used to. This new job of mine is keeping me a little busy, so I'm not quite, I haven't been seeing the latest commentary.
Didn't the Supreme Court's decision in the first Obamacare case put some limits on the Commerce Clause?
Yes and no. Did the Supreme Court use words that suggested that there were limits on the Commerce Clause? Yes. Did the Supreme Court put meaningful limits on the Commerce Clause? No. And that's always their dilemma. Every time they try to put a limit on something, they end up with something that's, that just doesn't work. For every federalism rule, there's a ready workaround. And I include not just the Commerce Clause doctrine, but commandeering doctrine. For every one of them, there's a way to get around what the court said. And the Commerce Clause is particularly a good example, because I teach these older cases I was talking to you about, the ones pre-New Deal, as a constitutional romantic. Because typically in constitutional law, what you do when you teach those cases is you say, look how formalist and stupid these judges were, that they thought there was a difference between a chicken, and literally there are all these chicken cases and slaughterhouse cases, right? There's a chicken and the chicken comes to rest, and so it's no longer an interstate commerce, but when it starts to move, it is an interstate commerce, and trains are part of interstate commerce, but slaughterhouses are not. There's all these crazy distinctions. You actually, if you really are dorky, and I am, you can kind of catch the rhythm of it and sort of see what they mean. But usually those cases are taught with scathing disregard by academics. And they always say, like, how ridiculous this was and how stupid it was. And I always teach it completely empathetically, because I point out to my students, those judges are trying to carry out their constitutional duty, and they're failing. They're doing everything they can, and they are right to think that they're supposed to put limits on the Commerce Clause. And so the dilemma for all judges when it comes to the Commerce Clause is that you have a choice. You can either carry out your constitutional duty and say something stupid, or you can not carry out your constitutional duty and let Congress have free reign. But that's the choice set, and I felt like that was true for the Supreme Court's decision. I mean, Chief Justice Roberts is a brilliant lawyer. He's a brilliant judge, and yet he really struggled to articulate a reason why there was a limit. The same was true of another case, United States versus Bond, where Justice Scalia said, and I thought it was one of my favorite Scalia phrases, he said of the Bond case, it feels like a really good lawyer writing a brief for the wrong side. And I felt like that was what Roberts sounded like in the Commerce Clause case, because he just couldn't write an argument that cohered.
So there is no limit? Or if you were going to write the limit, what would it be?
I don't think so this is where I don't think you can come up with a limit that's going to fit any of the criteria that we especially fit for doctrine. I mean, you could ban interstate commerce, right? You could shut it down in certain ways, but finding a manageable principle, I think, There are enough great jurists that have tried to do it and failed. And I don't, this is what the confidence that some academics have that we can create manageable standards for this, I think is just entirely misplaced. So, and that's why I teach these quick cases is so sympathetically. They were smart judges. They were not unsophisticated about how these things work, and they just knew they couldn't do it.
Like all great constitutional conversations, I want this one to go on, but we have to end on time. So last question to inspire or discomfit the audience. Are you optimistic or pessimistic about the future of the Constitution in light of federalism, and what role will federalism play in the future of the Constitution?
I've been a little pessimistic in recent days so about the Constitution generally and our ability to carry it out. I think if I can answer it in the following way, I teach two things. I'm a specialist in federalism and constitutional law and also election law. And I feel like I became dean and stopped writing scholarship at just the right moment because I fear that for both my fields, they depend on a level of give and take that is quickly eroding in this country. So if I can just flip the question around, I'm not sure if federalism can save us from the democracy that we are building because the federalism depends on some measure of a robust democracy. And so if we are not willing to give and take, if we treat the other side as an enemy for all things and will not tolerate difference and debate and dissent, then I think it doesn't matter what structure you have, that this level of polarization, if it continues the way it's going and we continue to be, some of the things that we're seeing at war with one another, I worry that even federalism can't withstand it. Sometimes federalism fails. I think that in a normal democratic period, federalism just boosts and strengthens democracy. It's interactive. A good democracy feeds into a useful federalism system. Federalism feeds into a good democracy. But at this moment, the gale forces of polarization are so powerful that they may just knock down all the structural barriers that we have always used to channel our democratic impulses.
Well, if federalism fails, then Yale Law School and the National Constitution Center will continue to promote these cross-partisan conversations that will save democracy. I have to say that when I was in law school, Bruce Ackerman had a standard for grading, which was very simple. It was either check or I. And if you got an I, it means you had an idea. And it was really hard to get an idea because it's hard to have ideas. And in this conversation, you have given us so many ideas to think about. You have educated us and illuminated, and please join me in thanking the great Heather Gerken.
Thank you very much. That was wonderful, Jeff. Thank you so much. I really appreciate it. Thank you. Should we